Hello and welcome to today's session on the NHS provider selection regime. I'm Patrick Saunders, an associate in the public sector team here at Ward Hadaway.
And I'm Tim Kerr. I'm a partner in the public sector team at Ward Hadaway.
So as I say, in today's session, we're going to talk about the NHS provider selection regime. Could you give us a really brief overview of what that is?
Yes, very briefly. The NHS provider selection regime was brought in by new regulations that took effect on the 1st of January 2024. And they go by the snappy title of the Healthcare Services Provider Selection Regime Regulations 2023. But everyone calls them the PSR. So for today's purposes, that's what we'll call them, the PSR. Yeah, absolutely. Those regulations regulate how certain bodies, mostly in the health service, have to award contracts for services that are defined as healthcare services. And these rules are completely separate to any of the other procurement rules that we've been talking about in these sessions.
Okay, so that gives rise to a couple of questions. First of which, I guess, is what are healthcare services in these circumstances?
Yes, so it is a very particular term, healthcare services, and it's defined in law. And in this case, it's defined in the Health and Social Care Act 2012. I'm not going to go into the detail of the definition because, broadly speaking, it applies to the procurement of any service that you would commonly regard as a healthcare service which is delivered to individuals, to patients. And that includes mental health services, but it excludes social care. So social care is not caught by that. Okay. In fact, it's just as important to think about what isn't covered as opposed to what is. So the sorts of things that aren't covered are goods and non-healthcare services, like the procurement of medicines isn't covered. Procurement of medical equipment, that would be covered by the ordinary procurement rules, not the PSR. And even things like cleaning and catering and business consultancy services, things like that, even if they're very closely related to the delivery of healthcare services, they still aren't caught by the PSR. There are also rules about what regime you would have to apply if you were carrying out what's called a mixed procurement, i.e. a procurement of healthcare services and non-healthcare services. Broadly speaking, it's a question of which one's the largest. So the one that's got the largest proportion kind of wins. You follow those rules.
Okay. And which bodies have to comply with PSR?
Well, again, there's a definition. In this case, it's relevant authorities. So the PSR defines what's meant by a relevant authority. And those are defined to include NHS England, integrated care boards, NHS trusts, NHS foundation trusts, and also, in the right circumstances, local authorities and combined authorities. All of those bodies have responsibility for commissioning healthcare services in our current health sector.
Okay. And so how does that sit with current procurement rules, but also the Procurement Act when it comes into force?
Yes. Well, let's add a bit of context here before I answer that. So before January 2024, the public contracts regulations, the 2015 public contracts regulations, also applied in many circumstances to healthcare services. But just to make things complicated, there was also a separate set of NHS competition and procurement rules that also applied to healthcare services. So there was always a certain amount of uncertainty as to how the regime was supposed to apply. And a number of lawyers and practitioners in the health service were kind of crying out for this to be clarified and to be dealt with. With effect from the 1st of January, we now have that clarity. And as a result of the PSR, it's now clear that the procurement of healthcare services is actually excluded from all other procurement rules. So it's now only covered by the PSR. So you only have one set of rules. If you're procuring healthcare services, you don't need to look at any of the other procurement rules.
Right, okay. So I presume that then that means PSR is a simple method of procuring these healthcare services.
Well, yes and no. I'm sorry about that. Of course, that's always going to be the way, isn't it? Because there are actually 5 potential processes that a relevant authority has to choose from. 3 of those are so-called direct awards, and then there's a competitive process, which is a fourth one, and then another one that sits sort of in between. So there are 5 potential processes.
Okay, so quite a bit more complicated than I thought. Could you start by describing the direct award process?
Yes, and those are possibly the easiest ones to describe. So first of all, in terms of what they're called, that's really easy, because there's direct award process A, direct award process B, and would you like to guess what the third one's called?
I hope it's C.
Direct award process C, exactly. So I'll just walk through those 3 processes. So first of all, obviously, direct award process A. Now, that must be used by a relevant authority when both of the following conditions apply. Just 2 conditions. So there must already be an existing provider of those healthcare services, which the authority is looking to reprocure. And the authority must be satisfied that those services can only be provided by that existing provider. Right. So existing provider and only that existing provider can deliver the services. An obvious example is like emergency services that are delivered through accident and emergency units at the local hospital. It's pretty obvious that in most cases a commissioner will say, that's the only provider who can deliver that A&E service. The next one is direct award process B. Now this is quite different. This is where the healthcare services are of such a nature that patients are offered a choice of provider. So when you go to see your GP and the GP says you need an operation for something, and the GP says, I'll just show you the screen, you can go to any of these people, and it throws up a list of providers. Also, the authority mustn't restrict the number of providers who can provide those services, and it must offer a contract to all potential providers who meet whatever the minimum requirements are. Obviously, they need technical ability and expertise to carry out the service. And fourthly, there has to be a mechanism in place whereby those providers can actually come to the commissioners and express an interest in carrying out that service. So here, the sorts of examples are elective surgery, where quite often, you may have come across this yourself, where quite often, as a patient, you are offered the choice of where to go for that elective surgery. And there's no limit on how many providers can come into the market to deliver that surgery. So that's A and B. Direct award process C. Now, this is different to A and B. A and B must be followed where those conditions are met. C can be followed. There's a discussion where the commissioner, the relevant authority, is satisfied that another set of conditions apply. So the first one is that neither A nor B apply. So you've got to discount those. Then there has to be an existing contract for the provision of those healthcare services, which is due to expire. And the authority is basically intending to offer a new contract for those services. The new contract mustn't be substantially different to the existing contract. So it's procuring more or less the same services. And this is quite crucial, the authority must consider that the existing provider of those healthcare services is performing the contract satisfactorily, and it's likely that they will be able to continue to perform it to a sufficient standard. Now, if all of that happens, then you can direct award to that existing provider. So that's A, B, and C.
Mm-hmm. That is also quite a lot to take it.
It is. I realise that. So it maybe if I just summarise very briefly,
that would be great.
Effectively, then you can use direct award if there's limited or indeed no reason to seek to change from the existing provider or to assess competing providers, and that will be because either the existing provider is the only provider who can deliver those services,
sure,
or patients actually have a choice of providers and there's no restriction on those, on the number of providers, or the existing provider is satisfying the existing contract and it's likely to be able to continue to do so. And the authority basically just wants to procure the same or substantially the same contract. So in those circumstances, direct award is claimable.
Okay. Simple enough. If complicated. You know what I mean?
I know what you mean.
So can we come back to talk about the other two processes? Because you mentioned that there are, in fact, 5 possible ways to procure healthcare services.
Yes, that's right. So the first of those is called the most suitable provider process. And in this case, the authority can award the contract without having to run any sort of competition because it can identify who the most suitable provider is itself. Effectively, that's another form of direct award, but it's just the PSR doesn't call it direct award. So most suitable provider.
Okay, and when can that be used?
Well, first of all, obviously, the authority can't be required to use either A or B, obviously, and it's decided not to use C. So we're in the right zone at that stage. And the authority has to be of the view, taking into account all relevant information that's available to it, that it's likely to be able to identify the most suitable provider without running a competition.
Okay.
Now, I know that all sounds a bit academic, but actually, we've actually got some guidance now on how that operates, because there has been a decision by what's called the Independent Patient Choice and Procurement Panel, which I'll come back to again soon, where they investigated whether or not a commissioner had used the right process under the PSR. In this particular case, the commissioners had decided not to undertake any sort of pre-market engagement and not to update their knowledge of available providers and the sort of the market that was available to it, despite the fact that it was quite clear there were gaps in their knowledge. So the commissioners basically, just based on the information they had, decided that a particular person was the most suitable provider. This was taken to the panel. The panel on investigation decided that actually the commissioners had breached the PSR because they hadn't tried to get all the relevant information that was available about available providers. So if you remember, I said that the authorities got to take into account all relevant information that's available to it. Not that it has, that it possesses, but that's available. So there is an obligation to go out there and do some market engagement, some investigation, and that's what the panel found. Also in that particular case, by the way, the panel found that those commissioners basically had a strong pre-existing preference for that particular provider and therefore hadn't actually used a genuine open decision-making process. They'd already made up their minds. And again, for that reason, the panel decided that they breached the PSR. So the commissioners can be held to account for following the most suitable provider process.
So it sounds like that could be a potential pitfall going forward then. You have to demonstrate
Yes.
that you've done the research in order to follow it.
Exactly. So it's a pitfall for the commissioners, but of course it could be an opportunity for providers who think they've missed out
Absolutely.
and feel that actually they were an appropriate person to provide that service. And they might be able to say, well, we were sitting here and the only reason you didn't come to us is because you hadn't done your investigation. So, yes, works both ways.
Okay. And by process of elimination, I guess the final process is competitive process.
Indeed. We come finally to competition, and that's right. So that must be used when the authority isn't required to follow A or B and has decided not to follow C or the most suitable provider process. Also, by the way, the competitive process must be used if the commissioner wants to set up a framework for delivery of healthcare services. So it must follow a competitive process then.
Okay, so I think I understand the premise of the 5 processes. Are there any rules about how those processes are conducted?
Yes, there are. There are certain procedural rules. Again, I won't go into detail, but just to pick out some sort of salient points. So, for instance, if you follow direct award process A or B, then the relevant authority has to publish an award notice after the contract is entered into. So the contract's already entered into, but at least there's some transparency because there's a public notice that says we've entered into this contract.
Yes.
If the authority follows award process C, which if you remember is one where they've got an existing provider and they're just going to basically renew the contract, then there are a few additional transparency requirements. So first of all, the authority has to publish an intention to award notice before it enters into the contract, and that triggers a standstill period. And then when the contract has been entered into, there's then a contract award notice after the event, like there is for A and B.
Yeah.
Now, if the authority wants to follow the most suitable provider process, then there's an additional notice that it has to publish in advance of making the decision, telling the market that it intends to follow that process.
Okay.
So that will be published quite early on in the process before it has decided who the most suitable provider is, theoretically. And then finally, if the authority is following the competitive process, then again, there are a number of transparency requirements, not that dissimilar to those required for procurements that would be followed under the Procurement Act for non-healthcare services.
Make perfect sense.
Exactly.
So are there any rules about what sort of criteria a provider has to take into account when making an award of a contract for healthcare services?
Yes, there are some minimum requirements. So, for instance, if you're following either award process C or the most suitable provider process or the competitive process, then the authority has to take into account a number of what are called key criteria, and these relate to sort of health care policy requirements, and they have to follow certain national or local policies and relevant guidance. So there are some key criteria that have to take into account. In addition, for the same three processes, the relevant authority has to apply what are called basic selection criteria. These, again, will be quite familiar to those who are familiar with general procurement rules, because these require the authority to carry out some due diligence to ensure that the provider they're going to appoint is suitable to provide those services. So it's got the economic and financial standing, and it's got the technical and professional ability to actually deliver the service, which is not that dissimilar to general procurement rules, and just satisfying yourself as to someone's standing and their ability and experience to provide the service.
Okay. So you mentioned something about panel earlier. What is the panel and how does it operate?
Yes, well, this is what I referred to earlier. And again, just to repeat the very snappy title, it's the Independent Patient Choice and Procurement Panel. Now, this is quite important because unlike the other procurement rules that you and I have talked about, there's actually quite limited opportunity under the PSR to challenge an application, certainly in court. Now, the panel has been established by NHS England, and it has the power to review and give guidance in relation to the operation of the PSR in certain circumstances, although not in relation to the use of direct award processes A or B.
Okay.
So actually, it will only get involved, or can only get involved, where there's a process that involves a standstill period, which is only award process C or most suitable provider or the competitive process. And that gives any provider who feels aggrieved that they've been unfairly treated or missed out on a contract that they should have had an opportunity for, it gives them opportunity to raise their concerns with the authority during that standstill period. And if they don't get a satisfactory response from the authority, then they've got a short space of time in which to raise their concerns with the panel.
Okay.
Now, the panel doesn't actually have any legal standing to order a different result, not like a court can in other procurement cases. But it does carry a lot of weight within the NHS. And we've already seen since January 24 a number of decisions where the panel has found that the commissioner didn't use the process appropriately. And therefore, the commissioners have gone back and changed the way in which they procure those services. So the panel does carry some weight. Beyond that, theoretically, if a provider still feels that they've been treated unfairly or prejudicially, then they could always bring a claim for judicial review in the High Court. Now, that's quite a high bar to get over, but it is possible, it is available. I would suggest that it will only be used on relatively rare occasions, but nevertheless, I think it's an appropriate route to go down if a provider genuinely feels that the commissioner, the relevant authority, has somehow acted unreasonably in the way it's used the PSR.
I mean, the formation of the panel seems like quite a good idea. Sort of curtails or shortens the process for a challenge, but without making it legal, if you know what I mean.
Absolutely. And of course, the panel will have very specific experience on NHS healthcare procurement. So unlike High Court judges, where particular judges may not have specific procurement experience, the panel will be totally embedded within the NHS.
Seems like a good idea. So from your experience, does the PSR work well?
Well, that's a very interesting question because it's early days. But the fact is the NHS has been moving in this direction for some time, trying to create an environment, a procurement environment, where commissioners of healthcare services can direct award where that is the right thing to do. And in particular, direct award is an important and very useful tool in trying to create integrated services, which is where the health service has been trying to get to for many years, and it's driving towards that integration. And it allows the commissioners to help shape the way that services are delivered in a particular locality, and to shape that integration, where if everything had to go to open competition, they might get some perverse results and all sorts of different providers coming in, and that ability to integrate would be lost. So it meets that sort of policy objective. So in that respect, I think the regime is probably working quite well.
Okay.
Clearly, there are occasions when providers miss out on contracts, and I'm unhappy. And we've seen this, and we've been involved in the odd case where that has happened. Usually, a sensible approach in going back to the authority and pointing out to them the error of their ways, and pointing out to them that they've misused the PSR, can result in the authority rethinking its approach.
Okay.
But the lack of a definitive legal remedy certainly does mean that the agreed providers have to think long and hard about what action they want to take. The challenges that have been raised with the panel, or the referrals to the panel might be the better way of putting it, so far have been quite few and far between. And it's clear that the panel doesn't have a huge amount of resource to hear lots of these challenges. So there may not be that many occasions when it's a viable option. We'll have to see as it settles down. And obviously people are going to have to get used to working within that framework.
But it does seem to me like a fairly logical and simple regime, to be honest with you.
I think it is. Once you get over that hurdle of understanding the 5 processes, I think actually, and you understand the policy decisions behind that, I think you do start to see the sense and the logic, and it falls into place. Yes.
Brilliant. Well, thank you for that, Tim. That's really helpful.
Excellent. Thank you, Patrick.